It is now my distinct honor to turn this over to our esteemed panelists and speakers today, Jerry and Braden. Thank you.
Thank you, Tracy. Thanks, Jerry and Seifarth, for giving me the opportunity to come here and speak today to experience the fine Chicago climate. I'll be talking today a bit about the big workplace class action rulings from the last year and a bit about what's to come. So 2018 was a big year for employment rulings at the High Court, and none were bigger than Epic Systems v. Lewis, which closed off an avenue for workers to evade arbitration agreements. The Supreme Court has issued a series of rulings over the last 15 years or so empowering arbitration agreements. In response, the plaintiffs' bar and Obama appointees to the National Labor Relations Board developed a theory that the National Labor Relations Act's guarantee of workers' rights to engage in group activity supersedes arbitration, essentially making it illegal to block workers from filing class litigation. This theory was tested in the courts, with some siding with the plaintiffs' bar and others siding with the management side. The Supreme Court granted class cert 2017 to a trio of cases that centered on this theory, one of which was the Epic Systems case. In May, the split court ruled for the management side, with new Justice Gorsuch siding with the other conservative appointees in closing off this path workers had been using to avoid arbitration. The ruling quickly made a mark, with employers citing it immediately to send several pending cases to arbitration in whole or in part. In the longer term, it's likely more employers have their workers sign arbitration agreement now that these legal questions around their use are cleared up. But there has been some pushback, notably in the sexual harassment arena, where the Me Too movement has fueled proposed litigation blocking arbitration of sex-related claims and has led to a few companies, notably Microsoft and Google, some other tech companies, to let their workers bring sex-related claims in court. Some plaintiffs' attorneys have also taken a kind of be careful what you wish for stance in response and have filed a series of solo arbitrations against the same employer. And there's been some talk of states adopting what are known as Private Attorneys General Act statutes, which I'll discuss more later. Next slide, please. The court also issued a ruling last year scaling back its landmark 1974 American Pipe ruling, making it harder for plaintiffs to file follow-on class actions when one class theory fails. In American Pipe, the court said class actions toll the statute of limitations on the suit's underlying claims, with the aim of preserving class members' rights to sue if the broader class action is denied certification. China Agritech v. Resch asked whether this ruling also lets class members file new class actions outside the limitations period. Plaintiff Michael Resch had filed one such belated securities class action against Agritech following two failed class actions that had been filed within the limitations period. But the unanimous court said in June that the prior cases only told Resch's individual claims, reasoning that to rule otherwise would give plaintiffs, quote, limitless bites at the apple, sparing employers and other defendants the threat of years of follow-on class actions. Next slide, please. A third ruling, known as Encino Motor Cars, concerns a Fair Labor Standards Act exemption that excludes from overtime pay any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles, which Congress exempted with the rationale that these workers work long, unpredictable hours, often off-site. Encino Motor Cars, a California Mercedes dealership, had sought to use this exemption to beat an overtime class action alleging it unfairly denied overtime to workers known as service advisors. In April, the conservative appointees sided with Encino, declaring these service advisors overtime exempt. What's more, the majority renounced the court's long-standing practice of construing FLSA exemptions against employers, telling courts to give fair readings of the law's 24+ exemptions when considering overtime claims. Shortly after Encino came down, a New York magistrate judge cited the case in a ruling declining to certify an overtime class action brought by Barnes & Noble cafe managers, and will generally make it easier for employers to beat overtime misclassification suits going forward. Although it doesn't have the strongest class action nexus, the Supreme Court's ruling in Janus v. AFSCME is right up there with Epic Systems in the list of 2018's biggest rulings. The case asks the justices whether public sector unions can make the workers they represent pay reduced dues known as agency fees, which cover sort of administrative costs and collective bargaining, but can't be used to fund these public sector unions' political activities. The Supreme Court had said public sector workers could opt out of paying full dues, but had to pay these agency fees in a 1977 ruling known as Abood, rejecting claims from an upstart impact litigation firm that public sector dues are unconstitutional. That firm, known as the National Right to Work Foundation, continued to file suits challenging unions over the years, and last year posed the same question to the court again in the Janus case. This time, the court ruled 5-4 that all public sector union activities are political speech because they affect state action. It's hard to say what the ruling's effects have been. I spoke with some management and labor, union-side labor attorneys who said unions may become more militant under threat, which may seem to be being borne out by the rash of teacher strikes. The DDOL just put out its year-end union membership survey that showed a small decline in public sector membership along the same trajectory that it's been going for years. So it's hard to say, that has been a dramatic impact in union membership, but it's certainly a loss for labor. Next slide, please. While it doesn't hold as many fireworks as 2018, 2019 is shaping up to be a big year for workplace class action litigation. The year started off with a bang earlier this month with the court's ruling in New Prime v. Oliveira, which surprisingly limited arbitration enforcement, albeit in niche fashion. New Prime was an appeal from the First Circuit that asked the justices to examine the Federal Arbitration Act's exemption for, quote, contracts of employment of workers, quote, engaged in foreign or interstate commerce. Trucking company New Prime had sought to send a class action alleging it paid a group of independent contractor drivers sub-minimum wages to arbitration, arguing its contract with these workers weren't, quote, employment contracts because the workers weren't technically employees, as the term is generally understood now. But the court bucked its recent trend of pro-arbitration agreements, ruling that the contracts of employment language meant simply agreements to perform work when Congress passed the Federal Arbitration Act in 1925. And the Justice Gorsuch-penned ruling was unanimous, not counting Justice Kavanaugh, who wasn't seated by the time oral arguments happened. But the ruling isn't necessarily a signal that the court has had a change of heart on arbitration, as it concerns more a pretty clear-cut exemption under long-standing statutory construction principles than it does the FAA's presumption that arbitration contracts are valid, which kind of underscored the prior pro-arbitration rulings. It also leaves open questions of whether transportation employers can make contractors arbitrate claims under state arbitration or contract law. So stay tuned for that to be fleshed out. Next slide, please. The justices also heard oral argument this month in a class action case called Home Depot v. Jackson, which concerns whether counterclaim defendants can remove state class actions to federal court. The case has some convoluted history, not all of which actually involves Home Depot. The suit started in 2016 when Citibank sued a man named George Jackson to collect a debt he owed on a water treatment system, which he bought with a Home Depot-issued credit card. Home Depot was not a party at first, but became one when Jackson filed a class counterclaim alleging that the company was part of a conspiracy to sell pricey water treatment systems. Home Depot removed the case to North Carolina federal court, but Jackson was able to convince the judge to send it back to state court. The Fourth Circuit affirmed that ruling, sending it back to state court, and now the case is before the Supreme Court. The case asks whether Home Depot is a sort of, quote, defendant the Class Action Fairness Act empowers to send suitable class actions to federal court. The Fourth Circuit said the provision doesn't apply to counterclaim defendants, which Home Depot said in oral arguments this month opens a loophole that unfairly blocks a class of defendant from sending big money class actions to the federal courts. If there is a loophole, it's a fairly tough one for plaintiffs to exploit, since they can't do so without being sued in state court by another party. But for employers that would prefer not to fight class actions in the less predictable state courts, it's a decision to keep an eye out for. While defendants often prefer arbitration to litigation, they're a lot less fond of class arbitration. Fortunately for them, the court may limit class arbitration this term in a case known as Lamps Plus v. Varela. The case asks whether the Federal Arbitration Act blocks courts from applying state law to allow class arbitration even when a given arbitration agreement doesn't explicitly allow it. The Ninth Circuit did so in Lamps Plus, saying a provision in worker Frank Varella's contract with Lamps Plus, letting him file for arbitration, quote, in lieu of any and all lawsuits, let him bring equivalent claims in arbitration. Essentially, the court found that he had traded his right to file class actions in court for the right to file class arbitration. Lamps Plus argued this ruling misread the Supreme Court's 2010 Stolt-Nielsen ruling, which held that plaintiffs can only pursue class arbitration when there's a, quote, contractual basis for it in the relevant arbitration agreement. Because its contract with Varela didn't even discuss class arbitration, much less authorize it, there's hardly a contractual basis for it, the company said. A majority of the justices seemed skeptical of the Ninth Circuit's decision in oral arguments, with the usual suspects criticizing both the decision and the class arbitration mechanism overall. Taken with the court's recent history of favoring defendants in arbitration cases, new prime notwithstanding, it's likely the court further limits class arbitration later this term. Next slide, please. Another case the Supreme Court heard recently could see it limit the use of so-called cypre settlements, which are deals that pay third parties when it isn't feasible to pay plaintiffs. The court had previously signaled interest in reviewing this growing trend of cypre settlements, but hadn't actually opined on them. The case, known as Frank v. Gauss, challenges an $8.5 million deal ending a consumer privacy suit against Google. The deal pays the class counsel about $2 million, gives $5,000 apiece to 3 named plaintiffs, and in lieu of giving pennies to the 100+ million members of the proposed class, splits $5.3 million among 6 internet privacy nonprofits. The Competitive Enterprise Institute challenged the deal, saying it sets a dangerous precedent that could lead to a flood of cypre settlements that funnel money to attorneys' favorite institutions. But legal aid organizations and other nonprofits say cypre deals are a useful tool that make good use of money that can't feasibly get to plaintiffs. The court was generally skeptical of at least the Google deal at oral arguments in October, although it's hard to glean how they might limit cypre as a mechanism. It's also unclear whether they will do so at all, because days after oral argument, the justices directed the parties to file briefs on whether the named plaintiffs suffered the sort of injury that would have even given them standing to sue Google under the court's Spokio ruling. So it's uncertain whether the justices rule at all on the cypre issue here. Next slide, please. I'm also keeping tabs on some other employment law issues that the Supreme Court isn't considering quite yet, but may down the road. Chief on my list of cases to watch are a trio of cert petitions asking the court to say whether Title VII's bar against workplace sex discrimination covers sexual orientation and gender identity. For most of Title VII's history, every court to consider whether its provision barring discrimination, quote, because of sex, covers gay workers has said it doesn't, but that blanket of precedent has started to fray. The Seventh Circuit in 2017 became the first federal appeals court, to say that Title VII protects gay workers, overturning its precedent to the contrary in an en banc ruling. And the Second Circuit followed suit last year, while the 11th Circuit has had a few petitions to take a look at the issue, but hasn't overturned its precedent to that effect. Whether Title VII protects transgender workers hasn't seen as much disagreement among the courts, which have generally said anti-trans bias is illegal gender stereotyping under the Supreme Court's ruling in Price-Waterhouse v. Hopkins. But federal agencies are at odds on the issue. Under President Obama, the Equal Employment Opportunity Commission formally adopted the stance that Title VII protects gay and transgender workers, but the DOJ, Department of Justice rather, has taken the opposite stance under President Trump, arguing against coverage in the Second Circuit and more recently in the Supreme Court, where it argues for the EEOC on the cert petitions. The Supreme Court has discussed the petitions at several conferences now and could decide whether to grant soon. I think their next conference is mid-February, so I'm keeping a close eye on that one. Another case I'm watching closely is a ways away from a trial court ruling, let alone an appellate decision, but it's a big one. In November, a newly launched business group called the California Business and Industrial Alliance filed suit in California State Court challenging the Golden State's Private Attorneys General Act, or PAGA, which I mentioned earlier offers a way for workers to get around arbitration agreements. PAGA empowers workers to act as state attorneys general and bring representative claims against their employers for violations of California Labor Code. The case has major implications for workplace class actions in California because courts there have said it supersedes the arbitration agreement some workers sign. Because workers aren't bringing their claims, but rather bringing the state's claims, they can't agree to waive them, the court's thinking goes. The Industrial Alliance's suit calls the act unconstitutional, claiming, among other things, that it's allowed unscrupulous private attorneys to, quote, enrich themselves at the expense of everyone but themselves, filing a bunch of suits against employers, that it's nullified valid arbitration agreements under the Federal Arbitration Act, and has taken an unequal toll on small businesses and nonprofits. The suit is so new that the state hasn't even filed its response, but it could make waves in 2020 and beyond, especially if other blue states adopt laws like California's PAGA. Last but not least, and probably more notable for class action litigators in the last two items, I'm keeping an eye out for a decision on a cert petition that asks whether workers violate the Federal Equal Pay Act when they set new workers' pay based on their past salary. The EPA makes it illegal for employers to pay men and women differently for the same work, with 4 exceptions, when gaps are based on seniority, merit, quality or quantity of work, and, quote, any factor other than sex. The case, known as Fresno County Superintendent of Schools v. Rizzo, challenges a Ninth Circuit ruling that the Fresno School District discriminated against a female math consultant by starting her at slightly more than she earned at her last job, which happened to be a lower salary than men with her same job. The Ninth Circuit ruling, which Judge Stephen Reinhart penned shortly before his death last year, said that past pay is an illegal sex-based factor because it carries forward existing gender-based pay gaps. This ruling puts the Ninth Circuit on one end of a deep circuit split, and there's a variety of opinions ranging from past pay always being an okay factor or to it being okay in certain circumstances. As with the Title VII cases, the court has considered the Equal Pay Act petition at several conferences now, and if it grants cert, employers that base starting salaries on past pay in whole or in part are going to want to pay close attention. And that's all I have.